A last will and testament determines rights to the property of a person who died. People who are negatively affected by a last will and testament often attempt to challenge the will. In this video, we will go over scenarios when a will is considered invalid. Let's start with forgery. When a signature is forged with someone else's handwriting, or it's traced from a different document by using a light box or a window, that's a forged will, and that will is invalid. When names are erased or pages are replaced, that will is invalid as well. The way pages are replaced is that people take out the staples from the will, they put in new pages, and staple the will back together. If a person that had the will had dementia, Alzheimer's, or was strongly medicated, that can mean that the will is invalid. If a person that made the will was lied to about people who really should be in the will, or the will was slipped to a person under guise of a different document, a will can also be invalid. If there was undue pressure to make a will, if a person that benefits from the will is a caretaker of a person that made the will, or that person is a professional who helps the person that made a will, it's easier to establish undue influence because caretakers and professionals are in a bigger position to unduly influence the person that made a will. If there are missing witnesses to the will, you need two witnesses and one or both are missing. Or if the person that made the will didn't declare it to be their last will and testament, then you have missing will formalities that can make the will invalid. If you have any questions, you can shoot me an email, albertgurevich@gmail.com. Thanks for watching.